since before 2006. My current case that was decided this year on June 20th by our Supreme Court, the Yeary case, my client was arrested in 2006 in that case, and I started arguing source code a little while before that. It is a great issue that I truly believe in that it has gotten good results for me in a lot of different places. Cases anywhere from 2.5s, 2.6s, all the way down to 0.8s have been resolved over the last few years, and a lot of times due to the beast of this issue, which involves the source code. And the first thing I want to talk about is connection here.
Yeah, timed out.
The irony of this is that I'm up here talking about computers and don't know how to work one. And that should tell you that this is really not about computers as much as it is the issue itself. The source code is defined as the human readable instructions that are used by the computer to perform its operations. And that's any computer. That's what the source code is. And what we really are asking for in requesting this from out-of-state company CMI is we're asking for the digital version of this code so that our source code analyst can actually use a program and analyze how the program actually works. So when you talk about programming, you talk about the object code or source code, they're all very similar as far as what you're trying to do. And it's basically you're trying to get a hold of the program of the machine to find out if the program works as it should. The company that we're trying to get this from is located in Owensboro, Kentucky, and that is the reason that we've got to go through the certificate of materiality and use the Uniform Act to get this information. And both Davenport, which is Bubba's case, which is the one that's the language is on the projector now, and my Yeary case, they were both decided the same day and also both argued the same day. Both of those cases deal with the Uniform Act and the requirements that we must show in order to get this authorization for the out-of-state subpoena. And what we're looking at in the question that Bubba presented to me was, what kind of case do we need to hire an expert on involving source code? Well, that's an easy answer. If you've got a test result above a 0.08, or if you have a refusal that has been determined by the machine, in other words, it's not someone verbally refusing to blow or failing to give a sample at all. The one that Ralph was just talking about a moment ago where someone actually blows into the machine, both of those cases are the cases where you need to analyze this issue and argue for the source code and try and get that programming from the machine. The best case scenario is someone who looks perfect on field sobriety evaluations and blows a .12. But we don't get many of those best case scenarios. So really, my position on the source code is I've been taking any kind of case involving a breath test and asking for the source code on the machine. I also recently did that in a case involving a refusal where the result of the leaders on the Intox printout was a 1.09 was the printout result. So I also asked for source code in that case, and of course that would be helpful in determining how the machine came up with that amount of volume and also whether the client actually refused or not in the case. But I don't think I've ever had a case or a motion where I have hit the opposition that I have with source code. Prosecutors have called me everything from stupid to wasting the court's time, ridiculous. They called it a rich man's defense, they called it a game, a fishing expedition. It's really interesting how I can file a motion claiming their cop didn't have a reason to stop my client and doesn't offend anyone, but everyone gets kind of wound up about the source code for some reason. And it's something that I've been dealing with for years now. Unfortunately for them, I am a true believer. I have literally been drinking the Kool-Aid. I think this is a great issue, and I think that a company such as CMI that goes out and they are actually advertising and looking to become part of law enforcement. They're out trying to do this throughout the entire United States and selling Intox 5000s, Intox 8000s, many other devices they also sell to law enforcement. I feel like that we absolutely have a right to this information as far as the programming on the machine. We absolutely should have a right to have our own independent analysis done by someone to tell us if this programming is infallible as they would like to tell us that it is. I don't want Chevrolet to come in and tell me when I'm getting ready to buy a car how great the car is. I want someone independent to analyze the vehicle and tell me how good the vehicle is and whether it's reliable or not. The used car salesman is not the guy I'm relying on. And it's the same way with the Intox 5000, which is our only approved machine in Georgia, which is also built and also they do the work on them in Owensboro, Kentucky. When we have problems with them, they send them back there for any kind of repairs. The Intox 5000 is a very simple machine when you break it down into two parts. There is hardware and there is software. The hardware and software work together to come up with a test result. The hardware consists of the infrared source, the breath chamber or sample chamber, you've got a detector, you've got a chopper wheel, you've got a breath tube, you've got a number of different things that the hardware is part of the machine. You've also got a keyboard and a printer that is part of the machine. The software controls all of it though. Without the software, my expert, Mr. Tom Workman, would tell you that you've got nothing more than a paperweight. In other words, you couldn't do anything. So the software relies on the hardware, but the hardware also is completely controlled by the software. And what we're asking for is the programming on our machines in particular. There are a lot of different aspects of the Intox 5000 machine that are controlled by the software. For example, if you've ever sat down with the machine or seen a test run, once you hit the start button, the program takes over and controls everything. It will tell the operator, enter the name of the person. It will ask the operator for the permit number. It will ask the operator for the stop time. It will ask the operator, all of the date of the incident and the time will also be printed based on the actual computer of the Intox 5000. So the computer takes over, and then when the person begins to blow, the computer handles that completely. They determine whether there's a sufficient sample or insufficient sample. The computer will determine whether there's mouth alcohol, which is through a slope detector, and we'll talk about more in a minute. The computer determines the actual blood alcohol concentration. So there's a calculation done based on the computer program to determine which number to print out. So our entire program, the entire aspect of breath testing is controlled by this computer program inside the Intox 5000 machine. So what we're doing is we're using the Uniform Act to go to an out-of-state company to request this information, this programming. And that Uniform Act is under 2410-90 is the beginning of it. That's the short title of it. And it goes through, it's a very short number of statutes, but it's very important for what we're trying to accomplish in this case. And in Davenport, the Supreme Court has made the bar so low you could trip over it. It literally is a logical connection with the consequential facts, especially if few others, if any, know about these matters. Well, if you think about what we're doing here is the trooper or the officer doesn't know how the machine works. The trooper or the officer doesn't know how it's calculating blood alcohol levels. So the machine is doing all of that on its own. So the programming is exactly what we need to address as far as how this is calculating a blood alcohol concentration for our clients. The next case that we have dealing with this, and Davenport really dealt with the meat of the case. And what I mean by that is the meat of this issue at our Court of Appeals and Supreme Court for Davenport was, did Bubba have a sufficient showing for Davenport to allow this to authorize the out-of-state subpoena? The trial court, Judge Carlisle, denied it. The Court of Appeals upheld that, and our Supreme Court reversed that, holding that a wrong standard was applied at the trial court level. So instead of being material and necessary, the Supreme Court ruled that all you need to show is that they're material, and this definition is what they have used now. So it's a very low bar to get above that and to get this authorization for the out-of-state subpoena. What's interesting about the Court of Appeals and our other case is that again, I'm having trouble with the computer. Yeary v. State was a case where Judge South wanted this issue resolved. In fact, we had a pre-trial conference prior to the bench trial in that case, and she said, Greg, I want you to come in here, and the Court of Appeals has been dodging this issue on the source code. I want to put this case on all four corners. We did an A5 only charge, which is the per se violation only. The less safe was null pros. So we did an A5 only trial, and she said, I want all four corners to get this issue resolved so we all have more direction as it relates to the source code. So we appealed that issue after having the bench trial, stipulated bench trial for the most part. We had Tom Workman testify at the pretrial hearing, who's my expert out of Massachusetts. And by the way, Tom is a great expert. I know Matt Myatt does it and can do a good job with it, but Tom actually used to do source code analysis in his job at Hewlett-Packard. He worked for Hewlett-Packard and was in quality control. And before they sent out the computers and actually approved the programming, they had to go through him, and he was doing source code analysis exactly for HP that we're talking about we want done in this case. So he's a great witness for this particular issue in front of a judge or jury. And Tom testified in that case, so we sent it to the Court of Appeals, and the Court of Appeals ruled that we did not, and when I say we, I'm talking about me, they say that I did not identify a particular witness that needed to be subpoenaed. I named CMI as the party without naming a particular person at CMI. Well, the Court of Appeals pulled that out of the air. That was nothing that Judge South ruled on. It had not been addressed by us at all as far as at the trial court level. So the Supreme Court obviously accepted cert on that case, the petition, and came out that we could actually subpoena a corporation and they would be the more appropriate person or agency to decide who would show up with the information that we want. So they reversed the Court of Appeals on that issue. Obviously, the Davenport reversed as it related to the standard for the trial court, so both cases have been remanded at this point in time. Now, what's interesting about the source code is we don't know what the baseline is. In other words, we don't know where their baseline is as far as the subject. Is it a 150-pound man? Is it a 120-pound woman? Is it a 180-pound male? We just don't know any of that. So my belief is that we don't need to show health problems or any other issue to make this source code relevant and material, because we still need to know how the computer program is generally designed. We need to know how this program is going to actually compute a breath alcohol result, whether you're a man or a woman, whether you're 150 pounds or 100 pounds. So my belief is that if you have medical issues such as asthma, emphysema, one lung, I think all of those things certainly can add to this, to the issue here. But at the end of the day, I do not personally believe that we need to have a medical issue or a problem with our clients. And to get a little bit more explanation of the programming on the code here, I'm showing you on this graph a perfect breath sample. And this is not exact. This is generally speaking what happens when you give a breath. The bottom is the number of seconds, and the side is the BAC. And what you're looking at is when someone blows in the machine, it should have a continuous positive slope as it's going up. You should not have a drop at any point in time, because the deeper lung air you get, the more you're showing, the more it should be as far as alcohol, because it's going to be a higher concentration in that deep air. So as far as what we have here, that's your perfect breath sample. And what we're looking at is the slope detector is what we're talking about here. The slope detector is how the machine determines whether or not there's an invalid sample. And the invalid sample would mean that there's mouth alcohol in the case. If you look at what we have here, this is how we check the machine every quarter. The area supervisor goes out, blows into the machine with mouthwash or some other alcohol in his mouth. He's got 0 alcohol in his system, which gives you a spike that could be as high as someone being deceased, coming straight back down to a 0, and it should, once it gets to deep lung air, it should be at 0 or very close to that. So that's what they do to test this slope detector. And as you can imagine, on the machine, that is all controlled by the software. The hardware is going to be making the measurements and deciding what the actual results are. 30 times a second, actually, the machine is doing that. But the software is what's going to evaluate those results, the timing of those results, and determine whether there's mouth alcohol or not. And this is a perfect example of how important the programming is on the machine. So we've got a very easy example of how the machine can pick this up. Well, the next question is, if you look at this sample, this person's true BAC is about a 0.06. But you've got a 0.12 peak, and based on testimony of Tilson, who I've cross-examined before and recently this week, he indicated to me that this result would be reported as a 0.12. And the reason he said that is because the machine is assuming that the last result is going to be the highest, and the highest is going to be the most accurate. So in other words, based on their first perfect breath sample, it would be the highest, would be the last one. This would be reported as a 0.12, even though their BAC is a 0.06. And this is something that we never test our machines for in Georgia. We never have a drinking subject given mouth alcohol and have the machine tested. All of our testing is quarterly inspections is done by someone with no alcohol in their system. So we look at that one, and then we go to the next one. That's somewhere between an 06 and an 08 to be reported as a 0.16. Another example of a problem as far as results go. Then you've got another one. This is another example of how the alcohol, the profile could look like. And this one, they're above the legal limit, but not